I'm Drew Stevenson. This is from my administrative law class. And here I'm going to be talking about the case, the Commodity Futures Trading Commission, or CFTC v. Schor. This is a U.S. Supreme Court case from 1986 about pendant jurisdiction in agency adjudication. So let's dive in. In this case, the relevant statute was the Commodity Exchange Act, and it authorized the CFTC to adjudicate claims and counterclaims arising under its coverage. The parties were also free to pursue the counterclaims in any normal forum. Now, Schor is a disappointed investor. He lost some money in his commodities or futures speculating, and he filed complaints with the commission against his broker, who was Conti, and a commodities futures broker, and others, alleging that the brokers were violating the regulations, and Schor wanted reparations before the commission from Conti, the broker. Now, at the same time, Conti, the broker, was suing Schor because Schor hadn't paid his brokerage fees, and had sued Conti had sued Schor in regular district court, and so basically Schor had a negative account balance. So this is a kind of a garden variety contract claim, really. Schor counterclaimed in that court, claiming that he was actually owed reparations for regulatory violations by the broker, and saying that everything would be settled by the commission's decision about this, and said that Conti should have to file his counterclaim with the commission instead. So since Schor was basically saying we shouldn't be in court on this lawsuit against me for my negative account balance at the brokerage, instead this should really be before the Commodity Futures Trading Commission. So Conti withdrew his lawsuit and filed the counterclaim for Schor's negative account balance before the commission, as Schor had demanded. But then the administrative law judge for the CFTC ruled in favor of Conti and against Schor on both claims. In other words, rejected Schor's claim that there were regulatory violations and he was owed compensation, and agreed with Conti that Schor owed the brokerage money. That Schor was unhappy with this result, as you might expect. Schor goes back into federal court, challenging the CFTC's authority to adjudicate Conti's counterclaim. And he won at the district and circuit levels. But the Supreme Court, in this case, reversed. The Supreme Court upheld the CFTC's statutory authority to handle pendant counterclaims that are related to public rights adjudication under its purview. I hope you can see the relationship between these claims. So you have a brokerage that is saying, hey, you have a negative account balance, you owe us some of your brokerage fees, and then the account holder or customer is saying, actually, I've lost money on my investments, and I think that you have been violating regulations and owe me money. So in that case, the Supreme Court said that it was appropriate for the CFTC to adjudicate the claims together. So let's talk about the holding in this case. The court here held that Congress may authorize agencies to adjudicate private rights claims that are related to another agency adjudication under certain circumstances. And it sets forth some factors, and these factors are probably the most important takeaway students could get from this case. So I'm going to go through them one by one. The first is that it has to be a specialized area of law. So agency adjudication is fine if it's limited to the narrow field of cases that relate closely to the agency's regulatory purview and area of expertise, which is the case in Schor, instead of kind of cutting across the whole gambit of common law claims. So the agency wasn't like reaching out here and also addressing a personal injury claim that Schor had because he slipped in the parking lot or something like that. This is still about exchanges and brokers and so forth. So let's keep going. The court also had a second factor that said it's only okay for Congress to authorize agency adjudications of kind of private claims or pendant disputes if it preserves other aspects of judicial power, traditional Article 3 judicial power, like habeas corpus or holding jury trials and so forth. So, in other words, the agency can't conduct a jury trial. If you want a jury trial, that has to be done in court, and agencies can't do that. And the party in question has to have the option, at least beforehand, of choosing an Article 3 court for the private right that's involved. That's the third factor. The fourth factor is how traditional is the private right here? Is this like a really old school common law claim, the type of thing that we would have had at common law before, back in the colonial period or even earlier in the 17th century or 16th century? Or is this something that's kind of a novelty in our legal system or something that was created by statute in the modern era? So let's talk about the fifth factor, which is there has to be judicial review available in regular Article 3 courts. And this is an absolute rule or a deal breaker on questions of law that are private rights and not just a regulatory violation. The reviewing court is going to have de novo review. In other words, they can ignore the agency's findings and start from scratch with their own assessment of the facts and the legal matter. So there has to be the availability of judicial review. The sixth factor is that enforcement by a regular court will still be necessary. So even if a party wins a private rights claim during an agency adjudication, that party is probably going to have to turn to the regular courts to compel enforcement or to execute on the judgment. The agency does not execute the judgments itself. Now, I do want you to note a couple things here. The court in this opinion, the majority admits that Conti's counterclaim for unpaid brokerage fees before the agency actually did involve a private right that would normally be the domain of Article 3 courts. That's the third factor that I just talked about in the factors set forth by the court. But even so, the court says that the other factors involved here go the other way and outweigh that one factor in this particular case. In other words, we have several factors the courts are supposed to consider, and then they're supposed to weigh which factor comes out in which column. And note that the Conti's claims for unpaid fees really is a traditional private right. It's just a regular contract claim, as I said earlier. But the statute limits the CFTC's adjudication for private rights claims to a narrow class of actions related to its primary regulatory purview. In other words, the CFTC isn't saying we're open to business for anybody across the country who has any type of contract claim, we'll adjudicate it for you, right? It has to be related to commodities, trading and commodities brokers. So where does this leave us? Well, the Supreme Court still cites CFTC v. Schor, and it's interesting to see how they discuss it or distinguish it from other cases in this particular area of law. So they tend to talk about Schor and highlight the fact that the claim and the counterclaim concerned what the Supreme Court today would say is a single dispute about the same account balance, basically who owes who when we have a negative number in the account. And the agency's assertion of authority really involved only a very narrow class of common law claims in a very particularized and technical area of law. So, in other words, the area of law in question was governed by a really specific and limited federal regulatory scheme, and as to which the agency had really obvious expertise. And the parties had freely elected to resolve their differences before the agency. Remember, Schor is the one who, when he was sued by his broker for unpaid fees, told the court, no, this shouldn't be, this claim shouldn't be here because I already have a complaint filed with the CFTC and they should decide both together. And then when he didn't like the outcome at the CFTC, he basically tried to say it was unconstitutional for the CFTC to have decided the very claim that he had insisted be transferred to them. And I think that may have undermined his credibility before the court in this case. Also, keep in mind, just as a final point, that if the agency issues an order, it still has to go to a regular Article 3 district court to enforce that order. Conti is still going to have to go to the court to execute on the judgment and get paid. So, in the casebook that I use for my administrative law course, there's some notes that follow CFTC v. Schor. And in the first note, the casebook authors observe that before this case, that is, before Schor, administrative adjudication might be permitted by the Constitution if the case implicated public rights, or the decision maker was acting only as a fact finding adjunct to the Article 3 judiciary. But Schor offers a new theory that there is no violation of Article 3 if private parties consent to a different method of dispute resolution. And that concludes our discussion of the case CFTC v. Schor.